The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. We are here this afternoon for the submission of 3 cases. The first case, State versus Harris, is hereby submitted without oral argument. The second case, in the interest of JV, is also submitted without oral argument. And the third case will have oral argument, and counsel are ready, so we'll begin with Ms. Wenman. Thank you.
May it please the court, Ms. Nye. My name is Katherine Wenman, and I represent the state of Iowa in our application for further review, following the Court of Appeals' rejection of the district court's finding that Mr. Lucas Brown is competent to stand trial for first-degree murder. Driving that application is the recognition that this case presents a prime example of the issues inherent in our current de novo standard of review laid out in State v. Lyman for all competency cases. For that reason, the state asks this case to overturn Lyman and return to a bifurcated standard of review, where fact findings following a competency hearing are reviewed for substantial evidence. Currently, 30 states, so I might argue 31, review these types of evaluations for substantial evidence or clear error. One case that we cite to quite often in the initial brief and again in our application for further review is out of the Minnesota Court of Appeals. And the question that you might have asked yourself, and I know that I asked myself, was what the other states do. The rest of them review this for an abuse of discretion. All of these states seem to understand that there is an incredible benefit to being the district court in these instances, being the judge who hears.
Lots of other states do it. Why should we overrule our prior precedent?
You're right. It's not just that the other states do it this way. I think it's also more consistent with our own internal jurisprudence. I think we'd be hard-pressed to find too many instances in a criminal trial that don't touch on some sort of constitutional issue. I think our closest analog to this sort of a hearing is the substitute counsel matter, where if there is not a hearing held, we review that lack of procedure, that lack of process for under a de novo standard. But if the hearing is held, we review for abuse of discretion because we recognize that that's a fact finding, where the procedure, the constitutional protection, we review de novo.
There is fact-finding in criminal cases that we review de novo, such as a motion to suppress, right?
I think the difference here is that a motion to suppress is procedural. What is coming in or coming out or being held out is inherently procedural.
Procedural, too. I mean, it doesn't deal with whether the defendant is ultimately guilty or innocent. It deals with whether they can go through a trial or not.
Sure. But when we're looking at a motion to suppress, I think there's less emphasis maybe put on a credibility determination would be the distinction that I would make. It's a fact finding, but the district court there is also reviewing a cold record to figure out if evidence should or should not be let in. Whereas here, we're reviewing expert testimony.
And there may be, I've been thinking about this issue too. I mean, I think there may be something you're saying that maybe we could distinguish between situations where the district court is making a determination about something that happened in the past, where maybe if it's a constitutional question, de novo review is appropriate. And the other one where the district court is making a determination about something right in the present, sort of in front of it in the courtroom. And maybe that's a little bit different. I don't know.
I think that's a meaningful distinction that we can look at. I also think that there's something to be said about how much procedure was afforded Mr. Brown here, and how many experts are weighing in. The fact that the district court here had an opportunity to see Mr. Brown, which no other judge in the appellate system or in the state will have the opportunity to do.
Testify though, did he? You mean just he saw him as he was sitting in the proceeding? He didn't testify in this particular proceeding, right?
It's uniquely important in this kind of a proceeding because part of whether or not you're competent to stand trial is whether or not you're going to be able to sit through your own trial or how you'll behave in trial.
About how he behaved at the hearing?
I think that the 19-page order talks about how he seems to be capable of sitting through that hearing. The expert testimony, the expert reports seem to think that there might be some questions about if he's able to or not. But the larger concerns are about his recall, not so much his ability to sit through the time periods.
Very decisive. I mean, whenever we overrule precedent, we're undermining to some extent the predictability and stability of our law. Why is this a good candidate to overrule?
The stare decisis factors, I pulled this from Youngblood v. Youngblood, the dissent that Justice McDonald put out. In that case, reliance is obviously one thing to look at. I also think its consistency with other related decisions is something to look at, and I think that's really prevalent here. Workability is something really prevalent here. Something that is interesting to look at is that Lyman never went through the stare decisis factors when it overruled that, the line of case law that it overturned.
I mean, it was a pretty thorough opinion, and it talked about all the cases that went before it, and it pointed out some were sort of lay on one side and some lay on the other. So, you know, whichever way you went, you were going to overrule something. Is that wrong? Was it wrong in saying that?
I think when it goes through case by case, it recognizes the distinction that I'm asking us to go back to, which is the bifurcation. That if you are granted the process necessary, if you have a hearing, we review that for substantial evidence. If you are denied that process, it's reviewed de novo. So the cases that it goes through, it points to this, there being a difference, but that difference falls along that line. So I don't think that there is some disagreement in the case law that Lyman pointed to that really existed.
A little bit more about the district court's ruling. The court uses the term gives credibility to Dr. Jones' findings, but I guess I'm reading it in context, not so much as saying that Dr. Jones' sermon was more honest. It's really the district court's just saying that it believes the version that is being given. And I guess I'm trying to figure out what real institutional advantage the district court has if it's not really talking about who's lying, right? If it's just saying, well, I've heard two experts, and I think this expert seems better. I don't know what institutional advantage the district court necessarily has on that versus 7 of us looking at the expert materials after the fact.
Well, there might not always be such an advantage as there is here. I do think there's, one, the case law is very clear about the benefit of the district court in these sorts of circumstances, battle with the expert, what have you. Additionally, the district court makes a lot of credibility findings about maybe what is driving Dr. Anderson's decision-making, and I think that's really important in this case. He also, you'll see in the district court's final order, the 19-page order, that the district court doesn't out and out say that the IMCC's underlying findings are a lie of some sort. It simply says that they are inconsistent. And I think that is very important here. So hearing Dr. Anderson testify and justify his summary findings, after cross-examination especially, that, I think, would be really important to hear Dr. Anderson speak about in person. Well, not in person, but via telephone. Hear his voice as he talks about it.
Question about, so as you know, in, say, family law case, we have de novo review, but we give deference in some instances to district court findings, and that's also true in other de novo review situations. And so isn't that sort of possible here, that we just have de novo review, stay with de novo review, but are able to give some degree of deference?
Obviously, de novo review has built into it some amount of deference for credibility findings. One, I don't think that's what the Court of Appeals did here. They make an awful lot of credibility findings. And I think that that has to be, to some extent, what happens in a de novo review, that those credibility findings aren't the final arbiter. You're right, that's what happens quite often in a family law case. But beyond that, there has to be some importance to the different standards of review appropriately being in place. Otherwise, we wouldn't have them. There would always be de novo review all the time. So while I understand,
Said if someone's constitutional rights are at issue, then why isn't de novo review the better route that gives us that ability to be deferential to the fact finder without being bound by it?
my earlier point that there are rarely parts of a criminal trial that don't have somebody's constitutional rights at play. So
consistent with what we've done. I mean, if you look at our case law over the years on constitutional matters, we tend toward de novo review. I mean, maybe that makes the state of Iowa an outlier, but that seems to be our trend. So Lyman actually seems more consistent with what we do in most constitutional context, or I can't remember how your brief put it, constitutionally adjacent type inquiries. And it doesn't seem terribly difficult to do. I mean, we do it in family law cases. We do it in all kinds of other cases. So maybe our trend is de novo. Well, what's your answer to that?
there would have to be an awful lot of changes in how we review criminal cases if that's really the trend that we're moving to. I mean, think about sufficiency of the evidence, which, takes somebody's, base constitutional right to be tried by a jury of their peers beyond a reasonable doubt. We review that for substantial evidence, clear error review. And so while we might say that we will protect constitutional rights or put this higher standard there, I think it deprives us the benefit of the district court's vantage point at the same time.
The issue about whether or not the state was entitled to a second opinion at this stage of the proceeding. And it seems clear to me the state is entitled to, or either party is entitled to, an independent expert at kind of the initial determination of competency. It's less clear to me, given the structure of the statute, why the state should be able to do it at this point. So address that.
I think that the structure of the statute is a little bit unclear. I do think that we can read 812.3's allowance for an expert into this part of the statute, but even if you don't want to do that, we do have State v. Rodriguez that says if it's going to be an adversarial process.
That's different. If the defendant is hiring an expert to come and testify, to X, Y, Z about the defendant's mental condition, then the state has the right to have their own expert examine the defendant and testify to X, Y, Z. IMCC is not the state. It's not a party to an adversarial proceeding. It's the entity that's designated by law to do this kind of work. And normally, it's not really working for either side, right?
Brings us to a really good point, which is if this were the other way around and the defendant were the one challenging this sort of a determination, it would be a really different posture to say a defendant wasn't able to bring evidence to challenge that determination.
That's what I was going to ask you about. I mean, you realize that if we, you are opening the door to that. In other words, that the person comes back from Oakdale and you're going to have defense counsel filing motions, say, I want an appointment of my own psychiatrist, and you're going to be delaying all these competency determinations. I mean, if that's what the state wants to do, that's the price they'll pay.
Real process, we expect that parties will be able to bring evidence to support their position. And
Why would that? I mean, the statute is designed in a particular way that if the defendant is found not competent, the statute designates the particular treatment providers that have to take custody of him, try to bring him back to competency, and it's IMCC or the director's designee. The parties don't get to control that, and it seems like a much more custodial, caretaking relationship. So why should the state or the defendant be allowed to challenge it? If the defendant's not happy and he's found competent, the case is going to continue on, and he can always make an 812.3 motion and start the process over again, right?
suppose if it was merely meant to be a rubber stamp of the IMCC's finding at this point, there wouldn't be a hearing at all. It would simply continue on.
district court upon finding a defendant not competent and unable to be restored, right? 816.8.6 and sub 8 give the district court different ways to dispose of the case. So that's what you would have the hearing for, a contested case on disposition, not an evidentiary case 3 months after the fact when the statute says 14 days.
I do think it's important, though, to remember that you said it right there, a contested case. So if we're going to say it's a contested case, it's an adversarial proceeding, why would we?
But the expert is the person that the code has designated to care for the defendant. I mean, I don't see any provision in the code that gives the parties the right to contest what IMCC is doing. And maybe if you could point me to that statutory text, it would alleviate my concern.
This question, I also think it's curious, and that reminded me of it, that the state sends all of these people to, and I'm a former trial judge, and I remember these hearings very well. That expert that the state has teed up said, not competent. State asks for a second opinion, and I find it incredibly interesting that defense counsel calls two people from the same joint to testify for the defendant. So if you could address that as well.
And you asked the question, but if I might have some more time since my time has expired to answer it.
There.
You are right that these are IMCC doctors that are giving the position. The state does have an obligation to ensure that justice is being done. And so when they read that report, and it seems so inconsistent with the reports that are coming previously, and something seems a little off, I think it would be a dereliction of duty to not ensure that there's another opinion to make sure that everything is jiving. And if you read the transcripts, you'll see that the attorney said, if this opinion comes back, I believe he says, if the opinion comes back and they also agree that he's not competent, we'll continue down 229. There's clearly something stewing here that drives this request for something else to happen. And it plays out in Dr. Anderson's testimony when he says, we have pled for patients, we just don't have more time to treat him, even though the statute, as you might note, says they have 18 months.
Of duty if they didn't look into it. But I have never seen the other side of that coin. I have never seen the state get their people come that normally do, and they testify competent. And the county attorney says, oh, wait a minute, I want another opinion. You know, I've never seen the other side of that coin. So I question dereliction of duty. It just seems like they didn't get the answer they wanted.
That might be my turn of phrase and not theirs. But I do think, given the inconsistency that was here, it makes sense that the state's attorney said, we just want to make sure that everything's above board and make sure that there's not something else driving the concern.
Oh, go ahead. No, go ahead.
I mean, let me ask this one more time, maybe try and sharpen the question a little bit. I mean, Ms. Wenman, I could just envision that more often we'll be in the opposite situation. That is, you have a defendant that the state thinks is being a malingerer. The judge, being cautious, sends them over to Oakdale. Oakdale treats them, sends them back. And then the defendant says, I want to hire at state expense a psychiatrist, and I need 90 days, just like the state got in this situation. I can imagine the state would be kicking and screaming about that, wouldn't they?
You might notice in the record that that's part of what causes the delay, is that the defendant isn't quite sure if they're going to hire their own expert. That's part of what's baked into the delay here. So I think saying competency is an important issue, and all of the parties are aware of that, and we want to make sure that we do it correctly so that we're not putting somebody on trial who's not competent. I don't understand where the issue would be there.
So a little bit to piggyback on what Justice McDonald was asking about, if you're relying on 812.3 to give the state the opportunity to put on an expert in a restoration hearing, what allows, can you speak to the 14-day period in 812.8? And even if you could have an expert, what allows you to go beyond that 14 days?
It's the state's position that that's a directory rather than a mandatory duty, because the purpose of the timing statute is to ensure that a hearing is held. First off, I want to be very clear that
someone has been determined to be incompetent to stand trial, and IMCC comes in and says, and we can't restore him. So isn't that 14 days seems really important to ensure that competency determination is made at that time about whether or not he's been restored.
I think if the determination were the important part, then it would say that a determination has to be made in 14 days, not that a hearing has to be held in 14 days. And first off, to be very clear, a hearing was held in 14 days. So it doesn't say that the hearing has to be concluded in 14 days. It doesn't say that the district court has to make a final determination within 14 days. And so the 14 days says you better get here and make sure that this process is moving within 14 days, which did happen.
Transport the patient then to the hearing. If it's not going to be we're here to have the actual hearing to determine whether or not IMCC is correct that he can't be restored.
We allow for defendants to be present at all sorts of critical moments in in the defense of their trial, or to be there for all sorts of things. I don't know that that's the determining factor here. Seeing that my time has expired, I will see you again on rebuttal. Thank you very much.
Crack at it again in a moment. Ms. Nye.
Good afternoon. Again, may it please the court, counsel. Lyman should not be overruled. It was the de novo standard of review is the most appropriate and flexible standard of review that the appellate court should use to review a district court's determination of the competency of a criminal defendant. It's well established that constitutional issues are reviewed de novo on appellate review. And this is no different. And in fact, partly because of the importance of this the competency of a defendant underpins all of, it supports and undergirds all of the other trial rights that a criminal defendant has. This is not just, not that any criminal or any constitutional right's not important, but this is absolutely fundamental, and it supports all the other trial rights that criminal defendants have. But as well, so it's not only consistent with how this court views constitutional issues and reviews them, but it also it's supported by that. It's also flexible. Some of the concern that's shown up in the briefs is that this court can't give deference to the district court findings, and that was in the concurrence from the Court of Appeals, and there's no prohibition on giving deference to the district court findings on de novo review. He's not forbidden from giving deference. And in fact, often we give great deference when there are appropriate sorts of factual findings that are appropriate for the district court, that when it really matters, that the district court gets to see and interact with witnesses or the defendant or the experts. Think about Veal and jury issues, Batson issues. We're going to give great deference to the district court's finding on the credibility of the prosecutor's reasons for the strike, stuff like that. So there's nothing about de novo review that requires, that forbids this court. The other important thing about de novo review, and I think the reason that this court will review constitutional issues de novo is that it allows, because constitutional issues are so important, this court maintains control over the development of the law in those areas by having de novo review. That's sort of the underlying. It also, the other states that do it differently, there's a lot of them don't have rationale. A lot of them base it only on the fact that these are factual determinations. But I assert this is not your run-of-the-mill historical fact that needs to be found. This is a
Court kind of final competency determination made. What date was that?
I don't remember. I have the order.
Early mid 2022, right? Something. So just a practical question. So we're 2 years out. Let's assume we agree with the Court of Appeals that the defendant was not competent. What is the remedy? The Court of Appeals, I think, ordered him for further restoration. I don't know if that's appropriate, if that's a district court finding. I don't know if we just restart the whole 812 proceeding. I mean, these are time-sensitive matters. His health obviously fluctuates from month to month, at least according to the treating physicians. So what should we do in terms of remedy?
This also plays into the standard of review, of course. The Court of Appeals, and we got this question in oral argument there, what are our options on de novo review? And because in de novo review, ultimately, you get to substitute the final judgment, the final legal determination of competency, this court could substitute the judgment. But practically, as we know, everything in this record is stale now. We don't know. We're 2 years later. I think that also raises the question that if we would change the standard of review, this judge had 3 options. So even if you would decide, that the decision he reached isn't supported by substantial evidence, again, what do you do? And so I think at this point, I think he's got to either go back for more treatment or have another hearing, but then the clock is running on his, the statute only allows 18 months of treatment. The practical consideration is you dismiss this, and because this is a Class A, this is first-degree murder, civil commitment proceedings are going to start. The state will commit him, and if at any time he is restored to competency, they can reinstate criminal proceedings.
Or
The commitment has to be dismissed. Like if the court finds he can't be restored. Sorry. It's a
nature of this hearing. So the state's position is they get to have an expert witness. I'm not sure if you
agree. No.
I think you would say that if the state gets one, the defendant has one. But is competency even on the table at this hearing, or is it just disposition based on IMCC's determination that he can't be restored?
The statute presents all, if the court finds, A, B, or C, he's competent, he's not competent, but can be restored or cannot be restored. If this were held properly without without the state getting an expert and bringing in a new opinion that he's competent, what's on the table, I think still is he not competent and cannot be restored, or could he still be restored? Because we still have time on the clock. I don't think this has to be a rubber stamp of IMCC's decision. The court still has to exercise its judgment and apply, look at, it's not, like I said, it's not a rubber stamp. He has to read the reports, and if, I think a lot of times these cases might be just held on the reports without testimony.
One of the questions I had, really reading both the Court of Appeals opinion and the district court opinion, they really seem to mostly be analyzing the reports. They're not like assessing the truthfulness of these particular witnesses. They're mostly just looking at the reports to try to explain this, this interesting pattern where he seemed to be on the road to competency and then seemed to veer off that road. So I'm not sure there's a lot of credibility weighing going on at either level. Am I misreading it?
Nothing about, there's not, if the court had made findings and the defendant acted a certain way or was, there could be, in a competency, you can imagine a competency hearing where it's going to matter, that there's going to be findings that are based on how someone is, the judge is face to face.
Usually, we think with experts that maybe there's less of a need to weigh their credibility. We often have experts testify by telephone or read their depositions into the record. We don't think it's important necessarily for the jury to see them in person. And sometimes, we're concerned as judges that an expert who, wows the jury might be less qualified than the one who doesn't wow the jury. Am I missing something there?
Absolutely right. I think that's a key part of this, some of the complaint about we need to give deference to the district court's findings, but there's nothing about the district court's findings in this case that can't be done just as well by the 7 of you.
the facts way better than I do. So you stated earlier, and I had a recollection that that's true, the Chapter 812 allows for 18 months restorative efforts. What stage of the game did your client's efforts begin, and what stage of the game did the court receive notice that can't restore him? How much time had transpired? How many months?
Yeah. So there's still,
Like the state was arguing that, you know, there'd been this waffling of an opinion and we had to do something about it. That's why we hired a second one. Wouldn't it make more sense to send him back? It looks like they were doing it quite frequently. Send him back, send him back, send him back. So what was the fire?
I don't know. The court didn't, I don't know why the court, I mean, I totally disagree with what the district court found in this case, that he'd been restored. There was still, you mean what's the fire for IMCC?
I mean, I don't understand why the court didn't just keep sending, I mean, it's pretty routine to keep sending them back.
Oh, I don't know why either, because I think that option was on the table.
Made by defense that, hey, give him more time.
No, they just, the heart of the hearing was discounting this new expert's credibility, or not credibility, new expert's report saying he's competent, that I met with him for 90 minutes and he's fine.
Really? Does it, after you go back and forth, if I remember right from looking at the record, there's like maybe 5 times they were going back and forth. It was almost like monthly or every 6 or 8 weeks they were getting new updates about who he's doing pretty good. Oh, he kind of had a bad day, whatever. So that was going back and forth. And then you have this hearing with the battle of the experts, or the first hearing saying, we think he's beyond competency. So then the state says, hey, we want a little more time. How did that first hearing get set? Did the court decide it on its own? Or did the state say, let's move to the final determination? I want a final report. I want to be done with this.
He was not actually, there weren't hearings held, there were reports to the court on appropriate. Eventually, the report comes on February 1st that says he cannot be restored. We've reached this conclusion that he's not competent, can't be, no substantial probability he can be restored in a reasonable amount of time.
Here's the hearing, just that magic language, but
Yeah, February 1st.
wanted to say done.
One that said done, and they sent him, pursuant to the statute, they sent him back to jail because this hearing is supposed, and I think it's in the notice on the front that a hearing has to be held within 14 days. I believe the defendant moved for the hearing. I'm not sure if the court tried to schedule it. So, but the state initially, there was some talk that they knew the state wanted to get an expert. So there was a hearing held on February 11th. Where they discussed whether can we go forward right now and decide whether he's competent and, rely on IMCC, or does the state ask for an extension and ask to have more time to hire an expert? And so then that's when it went beyond that 14-day deadline.
Question. If, in terms of disposition, when you're on the district court and you have cause to believe that the defendant may be incompetent under 812.3, you can set up a probable cause hearing, and then the parties can get independent experts, and you can make that determination. Is it possible that we could do the same thing here, given that so much time has passed? Because it seems to me, the de novo review versus substantial evidence review is a question we can resolve. But on the ground, whatever we decide, it's going to have very little relevance to Mr. Brown's actual condition at this state of time. So maybe we just set an 812.3 hearing and restart this process.
Yeah, I would disagree. At that point, we've got burdens issues. I think if you're going to vacate what the district court did, I think there needs to be some assessment of what the district courts found in relation to his competency, because I think at this point that we're having the hearing, there's a burden on the state to show that he is competent. When at the beginning there's a presumption of competency, and I don't think that's fair to apply that at somebody who's been committed for restoration treatment for 8 months. That now that presumption of competency should apply at this stage.
Question, maybe it's outside the record. You can tell me if it is. After the order came down and throughout the appellate process, he's no longer at IMCC, is he? He's at county jail? assume.
Hypothetically, if we overruled Lyman, would we call into question our practice of de novo review for a variety of suppression hearings where the court is evaluating the testimony of witnesses on what was the suspect in custody, was a confession voluntary, was a consent to search voluntary, listening to the officer and the defendant, body cam, all that? Is it going to be, are we going to be then asked to shift to substantial evidence review?
Imagine so. I imagine you're going to get a lot of arguments about that if this changes. I think that it's so well established that de novo review for constitutional issues and for the policy reasons that this court would want to maintain de novo review, that, and given, you can sort of make the pile of all the constitutional issues that we review de novo, and here's the few that sort of touch on it that we don't. I can't explain to you why there's a few that don't have that de novo review, but I think it would be a hornet's nest for sure.
Really quick CLE in like 30 seconds of, once that final determination is made, IMCC comes back and tells the district court we don't think he can be restored, and either the parties all agree or the court determines you're right, can't be restored. What happens to that person from here on out on a murder one charge?
The state has the prerogative to, if the person's not safe, the state has a prerogative to, and the state made it clear in this record that they would begin commitment proceedings. And so he would be most likely committed and continue treatment. I think I think the discussion on the record is that he'd end up at Cherokee. And if at some point in the future he's restored to competent, there's a finding that he's competent, the state could, because this is a Class A, the state could reinitiate criminal proceedings against him. The case could be revived. If this were a aggravated misdemeanor, things would be different. But given the gravity of the charge and his potential dangerousness,
Expiration of SOL, okay.
if they find he's not competent.
Anyone else? Questions of Ms. Nye? Thank you. Back to you, Ms. Wenman.
I want to follow up on something. So there was a case we had a few years ago, State versus Einfeld, that I dissented in, so I remember, because you remember your dissents better than your majorities. And this was one where the issue was whether a competency hearing, whether there was probable cause such that the proceedings should have been suspended. Do you remember that case? Have you read that case? Are you familiar with it?
Read it, but you might have to remind me some.
I think that's unfair when we say, have you read this case? We pull something that's not in the briefs. But anyway, so we said that on that issue, we apply a de novo standard review. And I take it you're agreeing that a de novo standard review is appropriate on what you call the procedural issue of whether you actually need to go forward on a competency determination. But it strikes me, because I think about that case, because I dissented it, that it should be exactly the opposite. It should be the other way around, because here we're reviewing just a bunch of expert reports, essentially. And that's an area where it strikes me the appellate court, Judge Bating is as capable of doing that as the district court. Whereas in a situation like Einfeld, the judge is there looking at the defendant, and the judge has the best perspective on, is this defendant really acting abnormally? Are they malingering? Is it somewhere in between? Do they understand what's going on? That and that's a situation where the judge is evaluating the defendant firsthand during trial, and yet you're saying, do de novo review on that, but substantial evidence or abuse of discretion on the other, and that seems to me backwards.
And why at first blush it might seem that way. However, whether or not somebody has to go through a competency hearing, Iowa case law, and I am sorry, I can't give you a citation for it right off the top of my head, but this court has said that that's an act that has no discretion, that that's a strictly legal question. And so I understand why it might seem a little backwards, but if we're going to say there's no discretion in that action, that I don't think we can apply any standard other than de novo. Whereas the decision of saying, I'm faced with two expert opinions that have conflicting end results.
Discretion there. I mean, the judge doesn't have discretion. You're asking us to review for abuse of discretion, but the judge has to decide if the person's been restored to competency or not. There's no discretion that if they've been restored to competency, you may still, dismiss the charges, or if they haven't been restored to competency, they can still be tried. There's no discretion, is there?
It's not discretion in the sense that I mean it in addressing your original question, but what I mean is that they are making a fact finding, whereas the original one isn't quite the same. So this decision, after they've been presented with a lot of expert testimony, a lot of expert evidence, as opposed to the very important but challenging job of a district court of pausing proceedings to figure out if more and say, hey, I need more information to figure out what's going on here. Please provide that to me. They're two different kinds of determinations. And so I don't think it would be out of the ordinary to say that determination of whether or not they should have stopped the proceedings to afford necessary procedure, which is a constitutional issue, should be reviewed de novo. I think that's consistent with our own case law, as opposed to this, which is a fact finding that should be reviewed for substantial evidence, the way we would sufficiency questions.
Imagining, okay, let's say that the district court's ruling prevailed. Jury trial, murder one. I've read some of the things about this guy as far as some of his behaviors, some of the things that were in the reports and stuff. Isn't that going to be an objection, probably a standing objection throughout the entire trial, and just be a huge, huge hickey on the transcript and every ruling? I mean, as I think Ms. Nye said, that's got to be the most fundamental, basic thing. And isn't that going to get challenged every step of the way?
That brings up an excellent point, which is that this restoration proceeding is not the final mark. If he decompensated or wasn't receiving necessary treatment or displayed these signs again, 812 proceedings could always restart. This isn't the final arbiter of this issue.
Go out and get another opinion. I mean, you could make that same argument against yourself. We should have just waited.
Because the difference here is that when IMCC said that he wasn't restorable, that sent us outside of the criminal context and into 229. And what we don't want to do is send somebody who is competent but dangerous into the wrong type of treatment facility. So instead to say, hey, we just want a second opinion. And when that opinion came back and said it's not just that he's restorable, but he is competent, that's what we presented to the district court, and the district court gets to make the final determination.
Assume that we conclude the state was not entitled to retain an expert at this dispositional hearing. What is the remedy then on appeal?
I think using substantial evidence review, which again I posit is the proper standard of review, you can look at the findings of the district court, which didn't just say, I think that Dr. Jones-Thurman is better. It also looked at the findings of the IMCC and pointed to all of the points in those reports where he was at least moving towards restoration. And I think that there's still substantial evidence in those reports that say, at the very least, that he is restorable.
Remand for a hearing? I mean, if the entire proceeding was tainted by an expert opinion that shouldn't have been there, why wouldn't we just remand it for a new hearing?
I think that option remains on the table, but I also think you have an abundance of information here to make a determination.
To your time frame, what's your position on our disposition?
I'm sorry, could you elaborate a bit on your question?
Given that it's been 2 years and we're not really sure what Mr. Brown's competency level is right now, should we go back to an 812.3 and assume he is competent, or should we proceed as if, he is not competent and we proceed kind of where things left off?
It depends on the ultimate finding. If you determine that these proceedings were appropriate and you affirm the district court's hearing and he begins back into his criminal trial, and based on the time stretch, something has changed, then the district court absolutely has the discretion to call, or I'm sorry, does not have the discretion, is able to call another 812.3 hearing, and the presumption of competence, I believe, would have restarted at that point because he's been determined competent.
I mean, if we disagree with you and we need to send it back, if we don't believe that, if we disagree with the district court.
Disagree with the district court that he is competent, or disagree that he is restorable?
Disagree. If we send it back and say that the state should not have been able to, whether we agree with the district court or not, but if we agree with Justice McDonald's position that the state should not have been entitled to an expert, and we send it back to, and right, we disagree with the district court about whether or not he was in fact competent. Should he do we go back to an 812.3 given the amount of time, or do we go back to it being an 812.8 review of whether or not his incompetency is restorable?
I mean, procedurally, based on where the appeal was taken from, I think that we're at still the restoration proceedings. But I take your point that a lot of time has passed. Thank you all very much. I appreciate it.
Of State versus Brown is hereby submitted, and the court is adjourned for the day.